ask you guys something since we have a lot of people on the line so far. What do you think about, do you want to keep this webinar going every Friday, or should we start converting this to every other Friday? You can either chime in while we're waiting to get going, or you can use the chat. Because if you feel that we're that since things are opening up quicker than what we thought, and you guys are going to be busy getting your protocols in place, and if you would rather do this every other Friday, we could definitely consider that. I already got one recommendation, said bi-weekly. Every other Friday sounds good. I think I'm leaning towards that too. That way we'll have more pertinent information, because not much happens. Yep, a lot of people are saying every other Friday. Not much is happening on a weekly basis. There's a lot more happening, if we have 2 weeks to report.
Well,
So,
it also, I think, Mark, it lines up with 14 days in each phase that we're going through, right? So I think that helps as well.
All right, we're gonna get started soon.
Yeah.
I think we could probably get going now if you want. All right, so welcome guys to our weekly webinar. Want to welcome everybody to our show and go over a couple different different guidelines. I'm Mark Cantor, the president of the State Association. We have a couple just rules that we like to put in place. First of all, this is a recorded webinar in case you want to go back to it later or you didn't have a chance to jump on today. Secondly, please, if you can, listen in the mute mode. Excuse me. The third thing is use the chat feature if you have any questions. That way I can read them to our guests that I'll be announcing very shortly. If you do want to speak, just please, as always, be respectful and announce yourself and your affiliation before you speak, so we know who's asking the question. I'm happy to announce that after doing this now for the last couple months, we've never had any issues with any affiliates or members, and it's been a pleasure to get together with everybody on a weekly basis just to keep in contact and provide pertinent information and answer any questions that you have, as well as bringing you qualified guests that might be pertinent for you or your club that can gain some valuable information. So with that being said, our guest today is an awesome friend of the State Association. His name is Jim Rubin. He's a specialty employment attorney. He has been the chair of the MSYSA Adjudication Committee for years, and he's also our legal advisor. And Jim is going to discuss many topics today, some concerning the COVID-19 pandemic and other issues that might be helpful for you, like coaching, W-2 versus 1099, and any kind of employment questions or issues that you might have that you might want to have answered. Any questions you might want to have answered. So, Jim, we appreciate you coming aboard, and as always, you've been a great friend over the years to the State Association. I know your soccer is a passion to you, and we really have been very thankful to have somebody like you that's been around all these years helping guide us legally through the trials and tribulations of running a state association. So Jim, why don't you take over and give us some information what you're thinking about.
Well, thank you. Can you hear me, Mark?
Yes, we can hear you.
Yeah, Mark, thank you for that generous introduction, and it's been my pleasure to serve the association for many, many years as the chair of the Adjudication Committee and as a legal advisor, volunteer legal advisor. And I appreciate all the work that the member clubs and the board and the full-time staff, and including Flo and Mark do on behalf of this great association. And I want to thank you all for having me as a guest. I really do appreciate it. My job outside of helping the association is I am an employment lawyer in Rockville, Maryland, and I've been doing this for over 2 decades, almost 25 years, representing employers and employees in regular employment disputes and problems, advising employers about policy, and then representing employees mostly in litigation. My most famous case is I had a class action on behalf of ticket office employees against the Washington Redskins, which turned out to be pretty successful. So I was one of the few people to sue Dan Snyder and win. So that's kind of a funny side note. But I have had a broad range of experience doing both employee side and employer side work. I've also done union work in my career, and a little bit of association work. So I feel like I'm fairly well qualified to give you some advice. What I decided today, both based on some input from Mark and Flo, is sort of go over the top mistakes that employers make, and could also apply to you as employees to keep an eye out for these. And you're probably all, and these also will very, very much affect the member clubs and the affiliates, because they tend to repeat over and over and over again. So what I'd like to do is maybe do real quickly, and I'm only going to take 10, 15 minutes of your time, the top 5 or so employment law mistakes that I think most everybody can relate to, and then address returning back to work and to you to play in the age of COVID. So you don't have to answer, but keep in your mind, what do you all think is the #1 employment law mistake? And it is the first question that Flo asked me, and you're probably all very familiar with it, but it is whether you classify somebody as an employee or an independent contractor. That's the #1, and I know that affects coaches and referees and trainers, and it's a question that has vexed the soccer community for years. If you search classify soccer coach as independent contractor in Google, up comes about a dozen articles from all the top soccer associations giving their 2 cents. So here's mine. The temptation to classify, coaches, especially coaches, as independent contractors is super great. And that is because it's so much easier to have an independent contractor than to have an employee. There's about 5 areas where it matters. Workers' comp is the #1 that comes to mind. If you have an independent contractor, you don't have to have workers' comp insurance for them. If you have an employee, you do. Same with unemployment. If you have an employee, you have to pay unemployment taxes. If you have an independent contractor, you don't. With minimum wage and overtime, if you have independent contractor, you don't have to pay them the minimum wage or overtime. If you have an employee, you do. You don't have to withhold taxes and collect a W-4 form for a contractor. For an employee, you do. For immigration purposes, you don't need to verify somebody's ability to work in the United States if they're an independent contractor. If they're an employee, you do. So all those things give great incentive for people to want to classify their workers as independent contractors. And it would be super easy. You could avoid tons and tons and tons of paperwork if everyone is classified as an independent contractor. But the problem is you don't get to choose who is an independent contractor and who is an employee. It doesn't matter what you want. That's not the test. The law in this area is it's your behavior that decides whether the person is an independent contractor or an employee. It's the one side, the employer side, and the individual side on the other, how you act toward each other. And so no matter what you call each other, that just doesn't matter. And in fact, you could be going along, and I've had cases where you could be going along for years and years and years, happily calling each other independent contractors. You could have a coach, a 10-year coach, who has happily classified themselves, and you're happy to classify them as an independent contractor. But then, after one bad day, somebody decides to make a challenge to that designation. And what are those bad days? Those bad days typically are the day after they get fired, and they file a claim for unemployment, and that would trigger an audit of if you're on the employer side, that would trigger an audit of what you've been doing. It could be the day after they file their taxes. Today it's July of 2020, July 15th, I think we got an extension. And they realize they've been paying both sides of the taxes, and they're paying self-employment taxes. It could be the day after they trip on the field and they suffer an injury, and they realize that they don't have and they file a workers' comp claim, and they want to assert medical coverage through you as opposed to their own health insurance if they have it. Or it could be the day they consult somebody like me, who takes a look at what they've been doing and asks them, the questions: have you been working more than 40 hours in a week? Have you been getting your taxes withheld? Has your employer been paying unemployment taxes? And so how you treat each other doesn't matter, because after that one bad day, your whole relationship comes to a challenge. And what is that challenge? Well, all the different agencies apply varying tests, and they're horrible tests. They're horrible tests. They tend to be able to be interpreted in varying ways. They are multi-factor weighing. And so somebody looking at it from one perspective could weigh it another way, but somebody from looking at it from another perspective could weigh it a different way. I'll give you one example. The test for unemployment, on whether you're a contractor or not, the very first test is the person free from control and direction? So what does that mean? I don't think anybody knows what that means. I mean, I would assume that every club has some control over their coaches. They're not completely free of control. So that raises the question: is every coach an employee for unemployment purposes? These tests are very difficult to negotiate. And so it's a liability, it's a risk if you are classifying folks as independent contractors. And you really should sit down with somebody, me or another attorney, to decide whether you are doing this correctly. And then that is because the penalties are really severe if you've taken the wrong choice. For unemployment, if you get audited after a claim, you would have to pay all the back premiums. It's not that much, but it can be bad. For overtime, the penalties are severe. It's often double the overtime or triple the overtime owed. If you Google soccer clubs, independent contractors, what comes up is horror stories about clubs owing back withholding and payroll taxes. But the one that keeps me up at night for my clients is if somebody suffers an injury on the field and there's no comp insurance. This is doomsday lawyer stuff. I happened to make sure I was right about this, I called a buddy of mine who was a comp attorney and asked them, what happens if an employer or a nominal employer shows up with no insurance? And sure enough, ultimately, the individual owners are responsible for the medical bills and the benefits. So it can be a real horror story if there's a problem on that. Some signals. So anyway, most employers, I just happened to, again, Google the other day. I mean, if you look at the legal experts who are advising soccer clubs, most of the legal experts are saying, you know, really most coaches should be classified as employees. Referees and trainers, I think there's a split of opinion on that. But the real test and sort of a rule of thumb is if you're in the same business as the person who is doing the work, that's a pretty good sign that they should be classified as an employee. If your relationship is long-term and indefinite, meaning there's no end date, it's not a project basis, that's another pretty good sign that that person is an employee. If that person has a supervisor, that's another pretty good sign that that person is an employee. So that, you know, lawyers are really, you know, loath to tell you to take risks, but if you're gonna do the independent contractor side of things, first you should really contact a lawyer again. But there are some things you can do. You can make sure that the person on the other end of the contract has their own entity, meaning they're incorporated in some way or they have a business. You can make them show you that they have proof of workers' comp insurance. And you can require that they affirm that they're going to pay the payroll taxes and the unemployment taxes. So that's the number one employment law mistake, and I think the number one that issue that's probably facing the clubs when it comes to employment law. I have total of 5, so I'm going to run. That's the longest one, so this one won't be so long. The second one is another misclassification issue, and that's misclassifying employees who are exempt, who are non-exempt as exempt. So exempt employees are employees who don't get overtime. If you're exempt, you don't get overtime. If you're non-exempt, you get overtime. And mistaking those two classifications of employees is the number 2 most common mistake in employment law. The overtime law was passed after the Great Depression, and it today is still the number 1 most common claim is a simple overtime claim. Like my Redskins case was a misclassification case. The Redskins misclassified their ticket office employees as exempt from receiving overtime when they should have been non-exempt, and we sued to collect the back overtime. So how do you know if somebody should get overtime versus not? Well, the Department of Labor has basically 3 tests, and if you Google exempt, exemptions, and Department of Labor, there is a checklist that comes up. And the 3 tests are, if you are truly exempt, you have to be paid on a salary basis, which means you get the same amount of pay every week, no matter how much or how little work you do. You have to make at least $684 a week, which comes out to $35,500 or so a year. And then the one that everybody gets wrong is the duties test. You have to meet a specific exemption duties test, and there are only 2 that I could imagine would apply to the clubs and to our affiliates. And one would be, is the person an executive? An executive under the law is somebody who manages part of the organization, supervises at least 2 people, and has the power to hire and fire. And the other one, which is the one that gets the most, gets it wrong the most of the time, is an administrative employee. And an administrative employee is somebody who does non-manual work related to operations and not sales. And they have discretion to do different, they have independent judgment and discretion as part of their job. And that's the key. So normal clerical, secretarial employees do not have sufficient discretion to be classified as exempt. Bookkeepers, if they're just making entries into QuickBooks, probably don't have enough discretion to be classified as exempt. And so you should really look at your administrative staff, if you have administrative staff, and decide whether you are properly classifying them as exempt from receiving overtime. Similar to the independent contractor, how you call each other, what you call each other doesn't matter. It's the behavior that matters. Does the person do the job? Does the job duties that meet the test? A couple tips on this. If nobody works overtime, there's no worries, right? Because this is an overtime exemption. So if everybody works less than 40 hours a week, it's not a big deal. Another tip is to have a job description. I know Flo asked me a question about job descriptions. It's a good idea to have them. There are a number of online resources. The one I like is the Society for Human Resource Management, SHRM, that sort of has a guide for creating job descriptions. And then you should ask, I mean, again, this is not the lawyer full employment lecture, but you should ask a lawyer to take a look at any job descriptions you think are close to the line. And again, another tip is if anybody is close to the line, it's always safer to classify them as non-exempt and pay them by the hour and pay them overtime. Somebody's take-home pay at the end of the year could be the same and would likely be the same if you're able to sort of estimate their overtime hours, whether you classify them as exempt or not. So it's sort of the safer route is to classify your administrative staff as entitled to overtime and keep track of their time. So that's the number 2. Number 3, again, a 5, I don't want to go too long with you, is the leave laws that apply to employers in the state. In 2018, Maryland passed a paid leave law requirement. So probably doesn't apply to most of you because it's got a 15 employee limit. So if you're under 15, then you have to provide unpaid leave, which means you have to give people time off and then keep their job when they return from leave. And there's accrual time. It's not an unlimited amount, it's a short period of leave. But if you have a staff of 15 or more under the relatively new Maryland law, they must get some paid leave. There's also something called the Maryland Parental Leave Law, which applies to employers with 15 to 49 employees, and that guarantees 6 weeks of unpaid leave for a new child. The most important one that probably applies to everyone is Congress passed in response to the pandemic something called the Families First Coronavirus Response Act. So this applies even to small employers, and it has specific provisions on paid leave that are directed to employees who are affected by the pandemic. And it's really 3 provisions. You get 2 weeks of paid leave if you're unable to work because you're quarantined or experiencing COVID-19 symptoms. Then you get an additional 12 weeks at 2/3 pay if you're unable to work because you have to take care of an individual who's subject to quarantine, or a child whose school or daycare provider is closed. And then this is the kicker. There's an additional 10 weeks of 2/3 pay if you have to take care of a child only whose daycare provider or school is closed as a result of the pandemic. So even small employers have to give this specific leave that was passed by Congress went into effect April 1st, right after the pandemic hit, based on COVID-related, circumstances. So if any of you have those sort of circumstances, you should take a look at the law, either give me or somebody else a call about that. There are Congress, so it's paid leave, but it's paid, there's a back end to this where it's paid with tax breaks. So Congress granted a tax break to employers on the back end. The employees don't see it, but it is paid through tax breaks given through payroll taxes. So those are the main leave laws that apply. I would mention one other one that is often mistaken, and that is if somebody has a short or long-term disability that requires some leave, oftentimes an employer has to give that leave as an accommodation for that disability. So no matter whether this person has paid leave left or you have an unpaid leave policy, if somebody is suffering from a disability, an employer often has an obligation to give some leave as an accommodation. And that can be a very fact-specific circumstance, but it's another leave situation that comes into play with employers. I'll give you the fourth of 5 biggest mistakes, and that is we've seen this, and I've been asked to give some opinions about this, is the use of non-competition agreements for coaches. So I'm not going to give you very specific on this, but I want to give you some sort of general advice on non-competition agreements in Maryland. More specific questions you can ask me directly. But the general rule in Maryland is you can have non-competition agreements. You can have reasonable non-competition agreements in Maryland. So that the $1 million question is, what is reasonable? And through hundreds of years of decisions, including decisions involving soccer coaches, Maryland has developed a series of sort of principles that govern non-competition agreements. Number one, it has to protect the employer's legitimate interests, meaning you can't use a non-competition agreement to penalize somebody for leaving. You can only really use a non-competition agreement to protect against competition, sort of an axiomatic rule. Another rule is you can't unduly burden the employee when you weigh it against how you are benefited. You cannot apply a non-competition agreement to a lower skilled and lower paid employee. You can't forbid a coach from just working for a competitor. You can only prohibit that coach from competing against you with that competitor. So we call it the janitor test. If your agreement says that the coach can't work for a competitor, well, that forbids them from working as a janitor for that competitor. And there are now Maryland cases that say if you make that mistake, the whole agreement can be voided. So the non-competition agreements I read, and including those involving soccer coaches, all tend to be way overbroad. The rule of the day, and as the law has developed, is the more targeted and narrower an agreement is, the more likely it is to be enforced. This is an area of law. Again, this is the lawyer full employment lecture, but I would highly recommend, because of the way this law has developed, that you get this read by a lawyer. And if you're a coach and you've been sued for a non-compete, or you're in a club considering suing for a non-compete, I will tell you that this is the divorce of employment law. It's where people spend money based on heart and not about, sometimes they're legitimate, but they are very hard cases to win. A lot of times the lawyers, are the chief beneficiaries of this agreement. I just had one that went on for years and years and years, which I was representing the employee, and we won at the Court of Appeals in Maryland, and no one benefited from it but the lawyers. Another consideration on these is consider a non solicit agreement. Those tend to be enforced more in Maryland than non-competition agreements, meaning you can prohibit somebody from soliciting a certain class of, would typically be customers, and those tend to be more enforceable. So that's number 4. Number 5, is one that Flo asked about, which is personnel files, what to have in them, what to not have in them. Generally, you want the, from beginning to end, soup to nuts documents. You want the pre-employment documents, so that would be offer letters. If you have an employee handbook, the acknowledgement that the person signed the handbook, their application, their resume. Then during the employment, any performance documents, that would be the performance reviews, anything related to compensation and discipline. And at the end of employment, if you have, letters of resignation or a termination letter or an exit interview, that's what will go in there. Where the mistake is made is what shouldn't go in there, which is generally private information. That would include, number one, is medical records. If there was ever a leave request or any other medical or an accommodation request, that doesn't go in there. Credit information, I don't know if you all do credit checks, and immigration documents, which typically have social security numbers. Those generally would be kept. Best practice would be in a separate file. So those are my 5 top employment law mistakes, issues. I just want to spend 2 minutes on returning to work and after the virus. Many of my clients have asked me to start drafting return to work documents. And, every day the world has been changing, and so they're very difficult to write. I've written a couple of them. I have consulted the main authorities on the return to work, which is the CDC. Though it hasn't published great guidance, it does have guidance. OSHA, and both here in Montgomery County and the state have published return to work documents. And here's what I've been putting in these return to work, and I'm not going to call them policies because they're changing so much. It's hard to say that they're a rule quite yet for workplaces. But what I've generally been including is, what is the disinfectant plan for your office? What are the disinfectant protocols for each employee? Do you require them? Do you have a station before they walk in the office to disinfect? And do you have throughout your facility disinfectant? So can you hear me still, Mark? Give me a thumbs up if you can still hear me. You can hear me. Okay. All right. I touched the button.
Yeah, you're
The other things I've been putting in addition to disinfectant issues is, social distancing in the office and use of common space. I just drafted one where we had a rule where it was one person in the kitchen at a time, and the document said only disposable plates and cups in the kitchen. The last one I wrote also had a rule on face coverings in the office, and the employer in that case provided the face coverings. I've also drafted them about governing travel, both local travel and out-of-state travel. And then some employers are doing, and the EEOC, which is the Equal Employment Opportunity Commission, does allow temperature checks. There's been a lot of debate about it, but they are currently allowed. You could conceivably do temperature checks as you enter the building. They could be self-administered or administered by somebody else. If you walk into a courthouse in Maryland right now, your temperature is checked before you walk in. You could also do, and I just drafted one, a daily self-certification form. So you have the employees certify that they do not have any COVID-related symptoms every single day. I have a larger employer client of mine is doing that through a online system. A smaller client of mine is doing that through every day. As you walk in, you got to check 5 boxes as you walk into the office. You haven't had a fever, you haven't had exposure to somebody with the virus, and so on and so forth. Flo asked me, what about fears returning to work? I have some fear about returning to the office too, and I think many employees do. And there's no easy answer to that other than having a policy and assuring the employee that you're going to do everything you could possibly do, and that they have a role to play, and of course they have to take ownership of their own health. But I think everybody is doing everybody's going to try to do, and most employers are going to try to do the best they can. But I would recommend that you adopt, if you're large enough. If it's a small employer, it may not be necessary, but if you're large enough, adopt a small policy and inform the employees about what you're doing when you return to work. And so that's it, Mark, on employment issues. I did a little looking about nonprofits. I'm not sure you want me. It's sort of outside my area, so I might.
Well, does anybody have any questions for Jim while we have him, as far as any specific questions about the W-2, 1099 issue, about maybe any kind of protocols getting back? I know, Jim, you really covered a lot. I think a lot of people really listened to some of this information. And if you would, on our chat line, can you just put in your law firm name and telephone number if anybody wants to reach out to you, or your email?
I will. Yes.
Yeah, you can just go right to the chat feature. Should be at the
bottom.
Doing
it now.
Huh? Okay, great.
I'm doing it now.
So if there's no other questions, we can move on. Jim, we really appreciate and thank you so much for spending the time doing some clarification on a lot of these issues that a lot of our affiliates have asked about.
Thank you, Mark, and I wish everybody at MSYSA a very quick return to the field, and I hope everybody stays healthy. Thank you.
Thanks. Okay, so everybody's well aware of, we had a lot of things are changing very quickly. In fact, while we were on this webinar, we got information that that Montgomery County is going to open their fields, and it's not confirmed yet, but someone posted it, that Montgomery County is going to open fields up next week. I don't know if that's for training purposes only. I don't know if it's for, if it's even more than that, but regardless.
Mark,
pardon me?
Yeah, so they're going to open up they're going to start taking permit requests for next Saturday, June 13th at 8 a.m., but it's only local park fields, so it's not regional parks, and I don't think it covers school fields, but it's just local parks, and they have a restriction. They have several restrictions, but one of them is only 10 players per field, and so it would be a 10-person maximum as with the phase that we're in now. So that's what it was today.
Okay.
It's training only.
So my point is, the good news is that things are starting, as everyone can see for themselves. Every week, it seems like it's getting a little bit better. For example, my son, who's 15 years old, does not play soccer, but plays lacrosse, and his team actually practiced yesterday at a church field in Olney, Maryland. And what the coach did, it had 2 coaches, 9 players and a coach, 9 players on the other side of the field and the coach, and they did drills and exercise and fundamental stick work. So, you could clearly see that things are little by little. I know that across the state, and Alan Lydiate, our director of coaching, is going to touch base on this in a few moments. There's a lot of different counties kids have been out in the fields training and things like that. We do have a question for Jim. Jim, we have one question. It says, can you touch a little more on the non-compete clauses in the coaches' contracts?
Yeah, it depends what you're asking for. I was just chatting on the chat. I mean, so I don't know what you're asking for, but the non-compete agreements there's a famous soccer case about non-compete agreements in the state of Maryland, and it was a famous soccer coach who was able to move large groups of kids because of his name, and was one of the few cases in Maryland that has enforced a non-compete with respect to a soccer coach. So the overuse, they're hard to enforce. They're easy to write and hard to enforce. So, you need to tell me more about what you're looking for me to give you any more definite of an answer. You follow me, Mark?
Yeah, I got it.
Yeah.
All right. So, anyway, before we get into Alan, so a lot of things are changing, and we're trying to keep up with it, county by county. Everybody's doing different things. We did hear you loud and clear about some kind of waivers. We are posting today a sample waiver for you guys to take and look at and use. We would recommend, it's only a sample. You might want to take it to a lawyer, your legal team, and just kind of go over it. But it's a good idea. It's certainly a good idea to at least use the sample as a starting point. And the most important thing, I guess, that we want to chat with you this morning is that Alan Lydiate, our director of coaching, is going to really talk about the return to play updates and all the changes that are happening. So, Alan, you want to jump on and give us the latest and greatest?
Yeah, appreciate it. Cheers, Mark. Just kind of an overview there of some of the things that I'm kind of going to touch points on. The sort of edited version of the return to play is now on our website, and I'm just going to sort of highlight some of the changes that we've made in the document. One of the things that we're struggling to find information on is essentially the goalkeeper and how we incorporate them into the session. And so we'll talk a little bit around that. Weather issues, that's something that I faced over the last week or so, just in terms of, obviously potential storms coming in because of the current setup and takedown sort of cleanliness issues, obviously kind of thinking and planning ahead to make sure if there is a, potential or a storm coming in that you basically call it earlier than maybe you normally would, just simply to ensure that everybody gets back to the car safely and and in the right manner. So just wanted to add that one in there as a kind of a I guess info just for thinking about when you're planning. Also next week we're going to do a sports session planner tutorial number 2. There is now a library in the sports session planner. The MSYSA sports session planner library is now classified as COVID-19. These are sessions from all around the world. So obviously utilizing those sessions, you have to be really careful and try and obviously take away what you need or maybe adjust the session. But we'll do a whole webinar primarily for club leaders, directors, coaches. If you have the sports session planner or if you want access to the sports session planner, it'll help obviously with planning your sessions and possibly providing some ideas on what can and can't be done during this period. So just as we move into the session, into the guideline, I apologize. I've converted this from a PDF quickly in the sort of last minutes into a to get it into the PowerPoint, so I don't have to switch. So some of the writing may be a little bit messed up on your screens. So the first one, if you just look, obviously we've highlighted the main changes. I think what's critical is obviously we always reminded that these are guidelines, they're not mandates, it's not policies. This really for us is about trying to find as much information as we possibly can to support you in, whether you create your own return to play guidelines for your own club. But obviously, again, you can copy or utilize our guidelines as you need, as you see fit. So, and again, from the beginning, we always said that this is going to be a live document. It would be adapted. And again, we've made some pretty big changes this week in relation to sort of last week's play on release from USSF. Some good ideas that we thought, and some things that we felt we need to add into the situation. So again, we always have to be reminded from the state. Obviously, Governor Hogan talked about moving to stage 2. We still have to be mindful of what your local county guidelines are, as well as what guidelines we're sort of advertising here as well. So I think the biggest change that we've put forth so far was essentially moving the phases to make it more simpler. Just excuse me a second. So the first component was really, a lot of people were getting confused about whether we're in phase 2, stage 2. It was very difficult for coaches to kind of keep up. And so what we did is we streamlined it similar to how USSF have done it. So the original phase 1 is now phase 0, so that we can match it up with the stages of the Maryland recovery roadmaps, just to make it more simple to understand what phases we're in. So phase 0 was essentially the virtual learning when we were obviously at stay at home. And so what we've done now is we've taken the original phase 2 and phase 3 and merged some of those elements based on some of the recommendations. And then obviously now that means phase 1 is essentially an adapted version of phase 2 and phase 3. So the biggest changes here, when you look at stage 1 or phase 1, because it now aligns, we still got the 8 players recommendation, 1 adult or 2 adults, 8 kids. The soccer balls now we've moved to maybe shared, so they're allowed passing and receiving exercises. So some of you, obviously, again, depending on your county, you may just be entering into phase 1, even though the state has moved to stage 2. So we would recommend, or I recommend, that you start at phase 1, even though, the state is allowing sort of stage 2 if you're just returning. Just because it gives you an opportunity to get used to organizing the players, laying out the field, and looking at some of the potential problems. So in this situation in phase 1, there's no goalkeepers, and that's something, again, that we're going to look deeper into, especially as it pertains to sort of phase 2. Again, there you can see goalkeepers are not permitted in that phase. So now as we move into phase 2, which is the stage 2 of the recovery. So now, again, as I say, it matches. We know roughly, we can see where we're at. The biggest thing that we're looking for, or that USSF kind of required, or their guidelines highlighted, should I say, was a minimum of 4 weeks in each period. So what they're encouraging is obviously, if you're just coming into phase 1, spend some time in phase 1 before you move to phase 2, even though the county or the state may have moved into stage 2 of the recovery. So each phase is given a 4-week process for you to adapt, and for obviously for the players to be able to adapt to the environment. This applies to teams, to allow the player, the coach, and the organization to sort of climatize to the environments that we're laying out for them. We've highlighted here the fully integrated goalkeeper training. Right now, again, we're at that situation where I think it's fine if you have an individual goalkeeper trainer that's working on, one-on-one, because that's minimalizing the risk. It's minimalizing contact with, surfaces and that type of thing. We are looking into it though as to, okay, can we incorporate that now into our training sessions? So in other words, can we start to use the goalkeeper? Can we start to take shots on the goalkeeper? Can we integrate them into the training session? And that's something that hopefully over the coming week, I will find more information that we can hopefully provide for you. Again, the goalkeeper's equipment is critical. Utilizing gloves and is handling a ball that's not necessarily their own. So there's still associated risks that we have to try and obviously try and reduce as much as possible. So obviously we're encouraging that they sanitize the gloves, prior and after the training session. Just quickly in phase 2, so another area is, and I think most people are asking, okay, can we go to small-sided games? So I think you can see number 3 there. Sorry, it's not highlighted. Physical contact that is necessary for training may occur. Whenever possible, it should be limited. Okay, so at phase 2, we're obviously saying that we can move to small exercises or games. I would still continue to utilize certain zones and separate players as much as we can, and always be mindful during the course of the training session, the interact and making sure that we limit the contact between the players. One coach, that I've spoke to, is like, right, great, we can do scrimmages now. We can do, a little Dutch tournament. Well, yes, we can do small-sided games, keep it minimal, but I think the most important thing is if you have 2 or 3, and this is where it's really, you have to be really careful. If you have 2 or 3 groups at the same site, so if you have, 10 players on each half field, you cannot interchange those players. So, if you're thinking, okay, well, we've got, we can make 4 or 5 different, small-sided groups and we can rotate them. No, they have to be within their group of 10, stay within their group of 10. We cannot be transferring the groups at this stage. So yes, for practice's purpose, on a team basis, we can look to start to do more small-sided games. Again, trying to limit the physical contact as much as possible. Again, some of the changes for phase 3, obviously we're gradually returning towards the full competition, and that will take a process of time. It's not as soon as, state opens up and says, okay, we're at stage 3, let's go. It's a gradual process. So be prepared to transition. Again, if you've only been at phase 2 for a week, we encourage that 4-week period to stay in a phase. Again, keeping in mind all the physical distancing as much as possible. So when they leave the field, no high fives, no fist bumps, still trying to keep the players at a distance as much as possible. I think that's large events, should be guided by local. Yeah. So again, your county, my county, I'm in Washington County in Maryland. The county announced the stage 2, but they also announced that, youth sports is still non-contact. So again, although this guideline says that maybe some areas can return to contact, I have to get clarity from the local government to make sure that that's in line with their protocols and what they mean by, is it completely no contact or is it minimal contact? So again, finding out from the county level is critical when you start to address some of these issues. think those are the main components. I will open it up. Any questions related? Again, this has been updated on our website. You know, I'll try to hit the major components. Like I say, the biggest one is the goalkeeping. We are still looking into that, and I'm hoping that we can provide more information on that in terms of the overall training. Again, you know, hopefully that gives you a little bit of guidance on where we are right now for stage 2 as the governor release. So, any questions for me? Great.
Okay, that's good, Alan. You covered everything so well, no one had any questions.
All right. They'll all come in about 5 minutes when we finish.
All right, so I'm not sure if anybody noticed, but our State Cup director was sleeping the past 30 minutes, but he finally awoke. And Brad Roos is going to come on and give us a update on State Cup and President's Cup. Go ahead, Brad.
First of all, let me say again that I hope everyone is safe and healthy. I wanted to thank Mark and Flo for having these weekly webinars. You know, I have communication with a lot of the states, especially in the East region, on a daily and weekly basis, and we're one of the few that are doing this. So I know it's really helpful. I've actually gotten calls from clubs and coaches from other states that are actually on our webinars to get more information. So thanks again for that. We have been holding out all kinds of hope that we would be able to still have a State Cup and a President's Cup competition this year. And just to show you, we have been meeting every Monday afternoon for the past three months, and have made change after change after change about what we could do to actually have the competition. And basically, we had promised that we would try to make a decision so that people don't have to hold off by June 1st. So the other day, we came to an agreement that basically, due to a couple of factors. Number one, looking at the current state, local, and CDC requirements, it did not seem like we would be able to have enough time to get those done in July, which was really our usage that we were looking at. Secondly, kind of going off of what was just gone over as far as the policies, really playing competitions, and especially in a situation where we have multiple contests at one location on one day, that phase would not occur until, depending upon what grouping you're using or what you're following, would be either phase 3, 4, 5. And again, I've been using more of USU Soccer's phases that they've looked at as far as in our meetings are concerned. And so based upon the fact that we're really still only in really phase 1, and that we would have to get to phase 3, at least 3 or 4, which would be a minimum of 2 weeks, that it really would not allow us to have any practice time for teams to get out as full teams and then hold the competition and be done by the end of July. And then the last thing was, we really wanted to make sure that the integrity of the competition was held, meaning that we were able to have the majority, or at least 50% of the teams that had applied, still participate. So we made a decision. We will not be having State Cup and President's Cup competitions for this year. That does leave a lot of questions moving forward for next year as far as seeding, teams that won the previous year. Those are all things that we'll work on as far as next year's competition is concerned. We did send out an email to all of the teams that participated or signed up for State Cup and President's Cup. A couple things I want to cover real quick. Number one, for all of the teams, we are providing a 100% credit towards next year's competition to teams. in clubs. The only exceptions that we would have, there are three basically. First of all U19 teams that applied and paid, they would be receiving a 100% refund. Secondly, any U18 team that had 50% or more seniors on that team would then be getting a full refund. And then thirdly, teams would be able to ask for a refund if they had extenuating circumstances regarding their team. And again, they would have the extenuating circumstances that would be something that would be, like, for instance, I'll give an example of one I received the other day, is that the team is not going to be a team anymore. The team is disbanding. So clearly that would be a reason for an extenuating circumstances. In the letter you received the other day, you did get information on how to fill out. So if you're a U18 team with 50% or more seniors, or you're in a situation of extenuating circumstances, you would go into the GotSport platform that you use to register for State Cup. And in there now is a form that you would fill out that would then go to the State Cup and President's Cup committee that would then have to be approved as far as refunds are concerned. Please also remember that lately the MSYSA sent out a list of clubs that still owed for either affiliate or registration fees from this year. And again, if we have not heard back from the clubs by June the 10th, we would deduct those fees from the credits and refunds that we're sending out for State Cup and President's Cup. In addition, though, we felt very strongly that we are going to try to do something to get teams and players on the fields before the summer is over. So right now, we're in the process of looking at holding a weekend festival at the end of July. And basically what this would entail is that we would have teams register for that. We would have an age group come play on either Saturday or Sunday during a particular time frame. And that during that time, those teams would play 3 30-minute half matches. So the basic idea being is that your team would only come on Saturday or only come on Sunday. You would play within like a 3 to 4 hour time frame. Then we would then have an hour break where those teams would leave. We would then do protocols for teams and bring in the next group of teams that would play 3 mini games or 30-minute half games. We don't have an exact date yet for that, and we don't have an exact location, but that information will be coming out. The other thing is we would not have a registration put together until July 1st, only because we want to look at the next month. What are the protocols going to be? What phases are we in? Is it even feasible that we would be able to have that festival? But we feel very strongly that if we can, we'll do everything we can to get players on the field. The board, in particular, has been very adamant that we do everything we can to try to get teams out on the field, if at all possible, this summer. We also said that if we have this festival, you could use your 2019, 2020, or next year's 2020, 2021 player cards. We'd allow you to use both, since it's kind of right at the edge of when we move to the next year's carding system. But all players would have to be carded in order to play, otherwise it wouldn't be covered by insurance. That's really kind of my report. I hope I covered everything. If there's any questions, feel free to ask them either on the chat or ask me now on the webinar.
Okay, another well-described discussion with no questions. That means that people are hearing you loud and clear, guys. The next speaker will be Jessica Hafer, our registration specialist. She's got some good information to go over. A lot of you guys and gals are waiting for this, especially about the another COVID waiver that she wants to discuss. Go ahead, Jessica.
Hello, everybody. So in discussions with MSYSA, and we have decided that we're in the process of embedding a COVID waiver for all players registering with MSYSA for carding for the upcoming season. So we're right now writing the verbiage, having it reviewed, of course, by our attorneys so that we make sure it is in line, and then having it, once it's approved by the attorneys, embedding it in the actual registration. So you as a club could obviously have one embedded specifically for your club and your needs for your program, but we will also be doing it on the MSYSA full registration site so that every single player that registers will have that as well. And it will be a printable form so that you can keep it if you select to have the forms printable, and so will the families, so that they can keep a copy of it for their records. Number two, I wanted to go over everybody. Thank you for joining us for phase 2. That has completed. The link to see the actual phase 2 onboarding recap will be updated under the registration tab on our website, msysa.org. So please make sure you're visiting our website. And once again, we will still need everybody to make sure that you're logging in to your GOT Sport admin under the club itself and selecting in the left-hand side user so that you can update all the personnel for your club so that they're receiving the communications necessary to help you through the year with registration and needs for your club. The third thing is we have now, since we've moved into governor's phase 2, we can have by appointment only in-person GOT Sport training. So for those of you that still were not comfortable with the webinars and feeling confident that you've set up your player program the way you want to, you can contact me. My phone number is on the slide at 410-330-8692, or email me at registration@msysa.org to set up a one-on-one training, so that in-person training, if you feel comfortable to do so. Again, of course, it is by appointment only, so it's imperative that you contact me and we agree on a date and time. And I guess, let me see if there was anything else. Yep, that's everything on my list.
Perfect. Thanks, Jessica. We have one question from one of our affiliates. They want to know how you get a comb through your hair.
I don't. That's,
You don't.
it looks like that.
All right. So the last slide that we have is questions. Anybody have any questions? I know that a lot of people were asking questions on the chat and they've been answered by different people. One reminder, we're going to start having these webinars every other week. So we will not have a webinar next Friday. We'll have it the following Friday. And we'll send out a note about that. And any questions? Seeing none, we're going to end this webinar. We appreciate it. We hope the legal advice helped your clubs. If you have any questions, you can certainly contact Jim Rubin, and he would, be able to help you with any of your employment questions or issues that you might have. Other than that, probably in the next Val, you finally came on. other than that, probably within 2 weeks when we meet again on these webinars, we might have a better clarification on the merger between MLS and US Youth. Everybody stay safe. You can start getting out on those fields in most counties for minimal training. And probably in 2 weeks from now, there'll be a big update on training sessions throughout the state of Maryland. See you, everybody.
Thanks, guys.
Have a good one.